Welcome to the 6th installment of the National Forensic Psychiatry Symposium. We hope to treat you today to an academic feast. In today's litigious times, all professionals dealing with psychiatric patients have to be aware of the latest updates in laws related to our practice, making forensic psychiatry increasingly relevant. So without much ado, let's start with the first panel for the day, Marriage, Mental Illness and Law. I would like to call upon stage our moderators for the first panel.
Our first moderator for this panel is Dr. Suprakash Chaudhary. Sir is the professor and the head of the Department of Psychiatry at Dr. D.Y. Patil Medical College, Pune. Area for breakfast to kindly join us as the program is about to start soon. This panel is Dr. Suprakash Chaudhary. Sir is the professor and the head of the Department of Psychiatry at Dr. D.Y. Patil Medical College, Pune. Apart from being the president of the Association of Industrial Psychiatry, Sir has been an editorial board member of 26 national and international journals.
Our second moderator for this panel is Dr. Sharmishta Deshpande ma'am, the professor and head of Department of Psychiatry at Srimati Kashibai Navle Medical College and General Hospital, Pune. Awarded with the Best Research Paper Award in BJMC Research Society Conference, ma'am has interest and expertise in licensed psychiatry. She is also a visiting faculty at various institutes for psychiatry and law.
Our third moderator for this panel is Dr. Manjeet Santre, the professor and the head of the Department of Psychiatry at PCMC's Postgraduate Institute and Yashwantrao Chavan Memorial Hospital, Pune. With about 10 publications to his name, Sir has a keen interest in the field of forensic psychiatry and addiction medicine.
To our panelists, I would welcome Dr. C. Naveen Kumar Sir, a professor and head, Community Psychiatry Unit, Department of Psychiatry, NIMHANS, Bangalore. Sir is a consultant for forensic psychiatry services and telemedicine and the first Indian to receive the Young Minds in Psychiatry Award.
I would like to welcome our second panelist for this panel, Dr. Nishikant Thorat. Sir is the Associate Professor of Psychiatry, BJGMC, Pune. Sir is also the Nodal Officer of the Addiction Treatment Facility, BJGMC, Pune. He has a keen interest in social and addiction psychiatry.
I would like to welcome Dr. B.C. Maltesh, Assistant Professor of Psychiatry, AIIMS, Hyderabad. He has a postdoctoral fellowship in forensic psychiatry and has published about 50 journal articles.
I now welcome Advocate Rama Sarode, an ILPTA certified trainer in neural linguistic programming. Ma'am also has about 20 years of expertise in the field of human rights.
Now I would like to call upon stage our organizing chairperson, Dr. Ivan Neto, chairperson Forensic Psychiatry and Law Specialty Section, Indian Psychiatric Society, to explain some ground rules regarding the panels.
Putting up the ground rules. The ground rules are for the smooth functioning of the panel so that all moderators, panelists and the audience can effectively participate in the panel discussion. Each moderator will ask a question to each panelist. The panelist will answer the question within 4 minutes. If he exceeds the time, there will be a bell rung. There will be in this panel 3 rounds of questions. The panelists are kindly requested to adhere to this time limit. After the panelists have spoken, they may interact with each other depending on the permission of the moderators, and then the moderators will declare the panel as closed. After that will be the felicitation of the panelists and of the moderators.
Good morning, everybody. On behalf of the moderators, I welcome you all to this session, very interesting session on marriage, mental illness and the law. At the outset, we thank the organizers for giving us the privilege of moderating this session. And now, without wasting time, I will request Naveen Kumar, Dr. Naveen Kumar, to give an overview of various laws relating to marriage and mental illness.
Good morning, sir. Good morning, everyone. Am I audible, sir?
Yes.
Yes, sir.
Yeah, thank you. So thanks the organizers, the IPS and the BGMC, Professor Ivan Netto, for having me in this today's program. That is first point I'd like to make. And secondly, see, when we talk about the laws related to marriage, India is such a diverse country, and the issue of marriage comes under civil jurisprudence, and India is home to many religions. So naturally, the laws related to marriage is not uniform, in the sense there are multiple laws covering different religions in the entire country. I'd like to tell another thing, that though in medical parlance the terms such as lunacy, idiot and those things are not there, but the acts still use those words, so pardon me for using such words. We have currently no other option other than that. So when we talk about religions and there are multiple acts. I will just read a couple of them. That is the Hindu Marriage Act, the Christian Marriage Act, the Parsi Marriage and Divorce Act of 1936, the Special Marriage Act of 1954, the Dissolution of Muslim Marriage Act of 1939, and so on and so forth. There are multiple acts which are related, not directly but indirectly related to these things. So, what is the common thread among all these acts? The common thread which is relevant to us as psychiatric clinicians or psychiatric physicians is the relationship of these things to the mental health and mental illness. So that is where so 2 points we need to think of essentially here, because I'm not a legal expert. So we have eminent legal experts for deliberating on this, but the issue is one of the capacity to consent. If there would be a problem if the person is incapable of giving valid consent as a consequence of unsoundness of mind. The second point is has been suffering from mental disorder of such a kind or such an extent as to be unfit for the marriage. So these are the 2 points that have relevance to mental illness. More or less, these things are present in most of these acts that I just mentioned in one or the other form. Either these are the conditions for either declaring the marriage as null and void or voidable marriages, because what is void, what is voidable marriages, we have other panelists for discussion. So I won't go into the details of that. And a few other observations are say before the 1960s, there were no definitive treatments for psychiatric illnesses. So marriages with mental illnesses were deemed incompatible, but that is not so now. We have moved forward leaps and bounds after that. So also over a period of time, what we have noted is the restrictions that the courts impose are not absolute. Say, for example, I think Maltesh and others would speak on various Supreme Court judgments. So I just want to, introduce the topic. Like, for example, there are many issues which are related to mental illnesses such as cruelty, or it could be fraud with or without mental illness, of course, but more relevant for those with mental illness, cruelty, fraud, impotence, consent by coercion, all these things, courts have been, the restrictions are not absolute. They take the issues case by case, including the apex courts. General principle is that the courts, generally prevent the dissolution of marriages. So, these are some of the things that I would like to tell in the beginning itself, sir. Thank you.
Thank you, Dr. Kumar, sir. That was a very important point, that now there are various new treatments available for mental illness, because of which all this perspective is actually changing. Now, next I would like to ask Dr. Maltesh that can you elaborate more? As sir said, there are various acts in various religions like Hindu, Muslim, Christian, Parsi. So how would that affect the marriage and mental health? Is there any impact as per the religion, or what would you consider in the practice of a psychiatrist? So let us look at it more from a practical point of view. I would like you to address this issue.
So, as it was just told by sir, there are different legislations basically which govern what is marriage and what is divorce as per different religions. And of course, there is one more legislation as well, which is secular, that is Special Marriage Act basically. Now, coming to the issues of mental health in these particular acts, it finds the mental health, the mention of mental health finds its place in three places basically. One is the definition of marriage, what is considered as a legal marriage. Next, what is considered as void or voidable marriage, and third is when it's considered as when the petitioner goes up, when there is appeal for a divorce basically. So when it comes to what is the criteria for a legal marriage basically, section 5 in Special Marriage Act and section 4 in Hindu Marriage Act basically define what is legal marriage, and there is mention of mental health in that. So for legal marriage to occur basically, the persons who are undergoing marriage, the both parties, they should be free from any mental illness that makes them that makes them not having capacity to give valid consent for the marriage. If they have any mental illness that makes them unfit to give valid consent, then that marriage is not valid in the first place itself. And then there is another criteria also, like if they are having mental illness and if they were having capacity at the time of marriage to give consent, but if they are unfit for marriage and procreation, then also the marriage can be considered as invalid basically. And there is another criteria, that is recurrent attacks of insanity. If that's present again, the marriage is considered invalid. This is as per Hindu Marriage Act and Special Marriage Act. Such criteria is not there in Muslim Marriage Act, that is Muslim personal law basically, it's not there. And even in Christian Marriage Act also it's not there. And in Parsi Marriage Act it's there, but the problem is there is no mention of mental health issues in the criteria for valid marriage basically. So this is with respect to what the criteria that are required for defining valid marriage. In continuation of that, when the criteria for valid marriage are not met, the marriage can be considered either void or voidable. In Special Marriage Act basically, if the criteria is not met, it is considered as null and void. The valid marriage did not ever occur. In Hindu Marriage Act, it's basically like if the criteria is not met, the three criteria that I told about recurrent insanity, attacks, or incapacity to give valid consent, then the marriage will be considered as voidable. On appeal by a petitioner, the marriage can be considered void. So that is one of the important difference with respect to valid marriage basically. And next part is about divorce. and another thing is in Parsi Marriage Act, again there is no criteria of there is definition for what is void marriage, but mental doesn't find any place in that again. Okay, and even in Indian Divorce Act, which actually governs the divorce for Christians, null and void marriage is defined, and mental health issues find a place there. Now coming to the issue of divorce. For divorce, again, the criteria is that if one of the person is, if the spouse is suffering from unsoundness of mind to such an extent that it is impossible for the other party to reasonably live with that person, then divorce can be granted basically. This is one of the common criteria for all the 5 legislations. But then there are some mild differences. It's not the same for all the criteria, all the legislations. Like for example, in Hindu and Special Marriage Act, there is no mention of time period. But in other acts like Indian Divorce Act for Christians and Parsi Marriage Act, and in the other one Muslim Dissolution of Marriage Muslim Act, in that the duration criteria is also mentioned. Like 2 years of insanity should be there to declare that divorce can be given. Otherwise, the petitioner can go to court only after 2 years of such an illness, not before that basically. So these are some of the important differences between different legislations of different religion with respect to what is marriage and what is divorce and what is null and void marriage.
Thank you, Dr. Maltesh. You have talked about valid marriage and legal marriage. But many a times in OPD, what happens, patient and their family members, they come with learned counsel. They come with their own lawyers, and then they talk about the legal terms like voidable marriage, annulment of marriage, void. So all these things, many a times, psychiatrists, they don't understand it. So I'd request Dr. Thora, can you elaborate on voidable marriage and annulment of marriage?
Yes. Thank you, Dr. Manjit. At the outset, I would like to welcome all delegates for this conference. Today, we are in 2022, but we are discussing these laws which are made in 1950s when there was no much treatment available for the mental illnesses. But still we have to, these acts are there, so we have to go by them and we have to study them. Just now Maltesh has talked about void and voidable marriages. So these are important concepts in while dealing with these laws. We should understand it better. So void means the marriage doesn't exist or is not legally binding from the inception. Means from the date of marriage, the marriage is not considered as legally binding, and the husband and wife, they are not the parties are not considered as husband and wife from the inception of marriage or from the start of marriage. Whereas in voidable marriages, it is legally binding and the parties are considered as husband and wife, but later one of the party can claim to the court that the marriage, they want to cancel the marriage because of certain legal problems or legal issues. So that is a voidable marriage. And in void marriage, there is no decree from the court is required. It is automatically cancelled, and there is no alimony required to be given, and is not legally binding. So while in voidable marriages, the alimony is to be given, and the parties can go to for the annulment of marriage. The annulment of marriage is basically legal process. It's like a divorce, similar to divorce, but it is a legal process like for cancellation of these marriages on the basis of mental health. So annulment is a legal process, and it requires to be cancelled. So now we see like what are the examples of void marriages or what are the voidable marriages. So from the inception, it is like if the marriage is between two parties where they are below age, or if the incestuous marriage, like between the blood relations, if the marriage is there, like sister, brother and sister, then the marriage is considered as void. And in voidable marriages, there are issues like non-consummation of marriage or impotence or if there is a like mental illness. On the basis of mental illness, as Dr. Naveen Kumar had just discussed, there are 3 clauses basically. So on that basis, the person, the party can go to the court and apply for an annulment of marriage.
Nice elaboration of the topic. Over to you, sir.
One common problem that psychiatrists face is in a family court, the people go for resolution and they refuse psychiatric examination. Now, can the family court direct them to undergo psychiatric evaluation, and what is the steps to be done if they refuse such examination? I will request Advocate Rama Sarode to enlighten us.
Good morning, all. I think it's a very relevant question because, like all the panelists here mentioned, that mental illness is a ground for annulment as well as for divorce, and sometimes practically when a case under the ground of cruelty is filed for divorce, they also take grounds for mental illness as being cruel to the other party or will fall under mental cruelty of the other party. Now, it is important for anybody, the person who makes the claim, the petitioner who makes the claim that this is the ground for me to go and get the divorce, has to prove that this is true. Now, how will they prove if the other person doesn't go for a medical checkup, and if that's necessary? Especially if mental disorder is the ground for annulment or for divorce, and until it is proved that there is something like this, that there is mental disorder to an extent that they cannot be in marriage or they cannot perform the responsibilities that come with marriage, then the court also cannot come to any kind of a conclusion. While I say this, I also understand that this is a very thin dividing line between forcing somebody to go for a medical examination versus the right to personal liberty, which broadly falls under a very important fundamental right under the Constitution, right to life, right? But any kind of a right is not absolute, and hence it has been made very clear in many high court judgments and in the Supreme Court judgment that when mental disorder is the ground that is being contested in the court, then the family court also has the jurisdiction to ask the person to go and get a medical examination done. So that does not violate the personal liberty of that person. Having said that, there could be a possibility that the person may refuse to go for the medical checkup. In that case, the court is allowed to take an adverse inference if they refuse to go for a medical checkup. But the court has to be very cautious in giving such an order, because there has to be sufficient proof to say that this mental disorder needs to be proved, or there is a chance that this person could have a mental disorder and is unable to perform the marital duties or responsibilities, and hence needs to go for a medical checkup. There should be a prima facie case, as we call it in the legal terms. Unless there is a prima facie case, all and any case cannot be sent for medical examination. So the court also needs to be very careful when they send such cases for medical examination.
Thank you. Advocate Sarode.
I think that was very useful information. Now we shall move on. I shall like to ask Dr. Naveen Kumar sir that what does our new Mental Health Act, MHCA 2017, say about marriage and mental illness? Especially, I would like him to elaborate on the section 105.
Thanks, ma'am. Let me read out word by word what is written in Section 105 of Mental Health Care Act. This section deals with the question of mental illness in judicial processes. So the question of mental illness may also come during many judicial processes regarding marriage and mental health and mental illness. So what it says is, if during any judicial process, before any competent court, proof of mental illness is produced and is challenged by the other party, the court shall refer the same for further scrutiny to the concerned board, and the board shall, after examination of the person alleged to have a mental illness, either by itself or through a competent committee of experts, submits its opinion to the court. So this is all Section 125 says. So essentially, it could mean that if there is any problem, if any party disagrees with the definition of with the presence or absence of mental illness, then that matter can be or shall be referred to the respective mental health review boards. The review boards can either on its own examine the matter, or it can refer to a committee of experts and then send the opinion to the court. So here let me talk about some practical aspects. Like Mental Health Care Act has been notified almost 4 years back, and how many review boards have been formed, and what is the level of awareness in the community and among various stakeholders about the formation of the review, about the presence and the functioning of the review board. There are even many states have not even notified the rules, mental health care rules, regulations, all these things are there. But of course it's better than the Mental Health Act of 1987 in terms of establishing the many statutory bodies related to the Act. However, the board has been it's like, it is my interpretation. I don't know. I mean, I'm not aware of any such issue having gone to the board and then decision has been made. But the board has been given. I mean, the review board, as we all know, is a quasi-judicial body, and that has been taken as the highest authority to declare the presence or absence of a mental illness. Here, another two important issues that I'd like to mention is the Mental Health Care Act talks about two different concepts. One is the definition of a mental illness, and the other one is the determination of the mental illness. The definition is, it says that to a degree, the disturbances of mental processes, to the extent the person cannot, fulfill the day-to-day responsibilities. It's a problem with thoughts or emotions or behavior to a certain extent. That is about the definition. But when it comes to the determination, it says it can be determined as per the existing standards. So all these complexities would come, and only time would tell what direction these things will go. But as of now, the review boards have been given this authority to take a call on whether there is any mental illness or not, if the other party disagrees to that in any judicial process. This is where I'm going to stop, sir. Thank you.
Okay, thank you, sir. So we are yet to see how this act and it will affect this course about decision about whether the marriage and mental illness, whether how much these boards they will interfere or they will take the decision making. That remains to be seen. So thank you, sir. I will move on to the next question.
Dr. Maltesh, what happens in our clinical practice? Many a times everybody faces the same question, like the family members, they bring the patient to OPD and they say, after marriage only she suffered from this mental illness, she or he, right? Before that he or she was absolutely fine. So my question is like, do this concealment of mental illness at the time of marriage, does it have what type of legal bindings, and is there any kind of landmark judgment? Because it's a kind of awareness among the family members also. So what is your view regarding this?
So with respect to concealment of mental illness, basically concealing any material fact amounts to fraud. that is one of the criteria to declare marriage as voidable marriage. In Special Marriage Act and Hindu Marriage Act, the criteria for voidable marriage includes concealment of material fact which amounts to fraud. So this concealment of past history of mental illness can be actually one such factor which can lead to divorce later on, or for annulment of marriage later on. We coming to the judgments which are given in with respect to this particular condition. Two landmark cases were I would like to quote. One is 1996 case Singh versus Kaur. Marriage occurred in 1982. Marriage lasted for early 10 days, and within that period, wife developed second episode of schizophrenia basically, and then husband came to know about the past history of psychiatric illness. He filed a case. In trial court and high court, divorce was not granted basically, but in Supreme Court, the divorce was granted, considering the fact that concealment of mental illness amounts to fraud, and marriage did not last long enough. I mean, it was very difficult for the husband to live with person who is having mental illness. So on that grounds, a divorce was granted. Another case is there of 2006 Saxena versus Pandit. Here husband had mental illness basically, wife was not aware of the mental illness, and after around 6 months of marriage, husband developed subsequent episodes, and then the court cases went on almost for 15-16 years, and finally Supreme Court again gave judgment that the divorce can be granted for this case as well. And on another recent case I would like to quote. These two are landmark cases basically, but these are relatively old. One recent case that I would like to quote is from 2021, just last year, Delhi High Court. Here again, issue was that marriage was done in 2005 and mental illness of wife was concealed. Wife had schizophrenia, and wife's father himself was actually lawyer, and he was the lawyer for the patient, and he kept fighting for the patient for almost 16 years. Again, 2005 marriage was done, and 2021 finally High Court gave granted divorce basically. Family court they went first, where divorce was not granted, but High Court granted divorce basically. And one case I want to quote which did not give positive outcome, that is Suresh versus Shweta 2018 case. Here again, wife had psychiatric illness which was concealed. Husband contested that this is a case of fraud, but that was not accepted by the court, saying that the marriage lasted for almost 2 years. After marriage, they were together for 2 years, and the past history of mental illness was just one episode in 2004 or 5. I mean, 10 years back there was one episode, and she was absolutely fine in the in between period. So even the mental illness was there, it's not to such an extent that it amounts to fraud. So not that every mental illness needs to be revealed, but if it's something that can seriously impair the person's ability to perform day-to-day activities of being a spouse, then definitely that needs to be revealed. If that's not revealed, then it's definitely a fraud. So that's my opinion, sir.
So, Dr. Maltesh, what will be your advice for clinical practitioners?
So my advice for practitioners would be that we should always encourage our patients to reveal their mental health issues to the prospective spouse. Without that, there can be chances of all these legal battle which will go on for years and years, and I mean, neither the patient will be happy, the other person will be happy, which they are going nowhere. If they reveal and then they get married, it's always better. So that would be advice. There is no legal binding, of course, there is no rules as such, but that would be the advice that we should give to our patients always.
Thank you, Dr. Maltesh. So we'll move on to the next question.
Next question is directed to Dr. Thorat. Please tell us something about the matrimonial rights of patients. If a divorce is granted, then who takes care of them? And is there any provision of the government taking care of the psychiatrically ill spouse?
I think because of these mental illnesses, as this has been one of the ground for divorce or annulment of marriage, our mentally ill patients suffering from like schizophrenia, bipolar disorders or major psychiatric disorders, they have to go through this legal battle, and this is very unfortunate that only the mental illness has been pointed. There are many other illnesses which are chronic or incurable, but these mental illnesses still is held as one of the ground for annulment or divorce, but that is very unfortunate. we need to see these laws to be reformed early or soon. As you asked, sir, what the matrimonial rights of a person or mentally ill person, they are the basic fundamental rights like any normal person have. After the marriage, a normal person gets a right to cohabitate or stay with the spouse. They have to they bear the children, they raise the children. So these children are legitimate born and they have legal rights also. Also the spouse have rights to their each other property. They can hear the property rights, and also there is a most important is the right to dignity and respect. Each person or spouse, they should be respected and the dignity has to be maintained. Just that the person, one of the spouse is suffering from mental illness, it should not be lead to cruelty or it should not be abandoned because of this. But in real practice, we do come across such many cases chronic long-standing mental illnesses. Either it is revealed after marriage and then basically the women suffer more and they are sent to their parents' house, and there is but legally there are provisions if there is annulment of marriage, then the spouse can be granted alimony to look after, but it has to be proved that because of the mental illness she or he is not able to earn and is dependent on his livelihood. So in that case the alimony can be granted. We have to take help of the existing laws in regarding this. But in especially women suffer more, and they have a triple tragedy in such cases, because once tragedy that they are also having mental illness, then they are separated, and the thing that they are living with the parents, and it is always a burden for the family members who are looking after such patients, and they are not working. So it is a very much tragedy towards the women who suffer more, and the male comparatively we see they don't have to leave their house. But we can definitely take help of the existing laws. Always, if there is no person to look after the mentally ill after divorce or cancellation of marriage, always the state is there. State can take cognizance, and state can care for the patient, and they can be kept in a mental hospital or care center where they can be reared, and the treatment. Also, there is a right for treatment also. If some spouse is suffering from any mental illness or any other problem, there is she has a equal right to get the adequate treatment for the same. Thank you.
Thank you, Dr. Thorat.
Now I would like to ask a question to Advocate Rama Sarode, madam. Divorce is a big stress. So when the divorce case begins, it is very stressful for either of the parties, and they make a lot of allegations which further increases the stress. And one of the important things that they say that they have been subjected to mental cruelty by the other party. So what is exactly included under this mental cruelty? We find it very subjective, or anyone may say that actually whatever behavior the other party is having, it is nothing but mental cruelty. So legally, I shall request you to throw light on this topic.
So, cruelty is a ground for divorce under most personal laws, I would say. And mental cruelty is part of defining cruelty. While there is physical cruelty, there is also mental cruelty. And I think you cannot just read the law related to divorce or family law in isolation. Now that there are new laws that have come up, like Sir said, that, unfortunately, our marriage laws go back, to the 30s and the 50s. While there are new laws that have come, for example, the Protection of Women from Domestic Violence Act of 2005 does talk of different kinds of domestic violence, which amounts to cruelty in a way. And it talks of physical, it talks of emotional, psychological, mental, it talks of sexual, it talks of economic violence. And all these also become ground for divorce. And so cruelty is the most used ground for divorce in India. And it has its connotation in various things. And yes, there is a subjectivity, because what is cruelty to me will not be cruelty to you. So obviously there is subjectivity in defining cruelty. And I think we have to understand it from the social and the cultural context of that person as well as of that milieu. For example, there are cases that have decided that not staying in a joint family or when the wife says, I do not want to stay in a joint family, is now not amounting to cruelty. Though we uphold and, we say joint family systems are good, but somebody who comes from a neutral family and wants to stay in a nuclear family, it's not considered as cruelty anymore. Or a lady who says that, I need a quality of life, and probably that quality of life will come through me educating myself, or to me going and working out and earning, now doesn't amount to cruelty. While somebody who says that I was humiliated, in front of others, or the demeaning way I was treated, or I was called names, name calling. And we've seen cases where there is name calling that happens and it feels insulting. Now this is also amounting to cruelty, because there's a mental agony that I went through. So there will always be subjectivity when we talk of, mental harassment or mental violations or mental cruelty. But cruelty on its own is a very broad term. Generally what we do is that, physical violence, not all physical violence can have a medical report, but some physical violence can have a medical report. But mental cruelty is a state of mind. It is about the emotional state of that person, and most of the time we do not have any kind of evidences to provide to the court. So as a practice, what I do is that I try and write the impact that mental cruelty has had on the person, for the court to understand that this is what she's gone through, or this is what he's gone through, for them to understand that this is why it is not okay with them, because there's a subjectivity to it. And most of the time mental cruelty cannot be proved by documentary evidences, and hence because now under the Domestic Violence Act, the person and what happens within the four walls of the family sometimes is very difficult to prove through documentary evidences. We do file, evidence. We file an evidence affidavit where I'm saying that on oath I'm saying that this is what happened to me, and then the other party gets to cross-examine them on basis of that to bring to the court if there are any loopholes. So it's a very tricky question, and there will be subjectivity. And in future, in the going by the way we are, progressing, or the new things that are coming up. For example, in the pandemic, we saw huge cases of domestic violence that happened, which amounted to mental cruelty. So I think we need to keep evolving with the definition of what mental cruelty would amount to.
Thank you, madam. As you have rightly said, even we came across many admissions in our ward secondary to exacerbation of mental illness due to increased interpersonal friction in the family during the lockdown. So we'll move on to the next question.
Good morning, sir. Sir, continuing this topic, what madam has started, like documentary evidences, mental cruelty and all those things. What is my observation in our practice? Maybe audience will also agree with me. Whenever a patient comes with their family members, with a newly married couple and all those things, so we start suspecting there is something. That's why all the family members from the female side, male side, everybody rushes to the OPD. So in such cases, how a psychiatrist should prepare himself, or how a psychiatrist should anticipate that this can become a legal problem, one thing. what type of documents he should be prepared with and how he should present himself in the court in case of marriage conflicts between the two families. So that's the question from my side, sir.
Thank you for the question, sir. It's a very, very important and relevant questions in recent times. The more and more acts are coming, so psychiatrists is becoming more and more forensic experts, so there is no other way out. See, we have seen in our clinical experiences all kinds of cases, like, for example, person with mental illness concealing and then getting into trouble. And we have seen persons, who had mental illness, they have concealed it for a long time enough for the marital bond to appear, and after that they have revealed, but then the marriage has gone on. We have seen cases where both parties have revealed that one party has got mental illness, and both of them have approached our clinics, and we have been able to give them information, and then the marriage has gone on. So all kinds of scenarios will have occurred over a period of time. But from a legal, professional, a professional point of view, psychiatrist is at a vantage point. One is he or she has to indulge himself in assessing proper assessment of the client in question, assessing the family, assessing the children, their mental health, how it is. So, either an inpatient assessment or an outpatient assessment can be done. One thing which needs to be kept in mind is that the psychiatrist has to be absolutely clear as to what all he wants, and he should not allow the other party to take a call on what they need. The psychiatrist has to decide what is what is essential, and then the relevant requisites have to be made to the patient party, and if they don't cooperate, that has to be documented. One is that. The second is having proper documentation, because ultimately what is written in the file gets examined, gets cross-examined. The psychiatrist will get grilled. So clear documentation of what is going on in the clinic, the clinical encounters. Another thing that I'd like to mention here is that while getting these documented, it is always better to have a parallel opinion with a colleague. Talk to the colleague in other unit, or in cases where forensic specialists are there, just to get a referral to them, have a discussion, getting more people involved in the decision-making process. Then the liability will be shared. The courts will give, credence to opinion, which has emanated from 2-3 people rather than a single person. Then the one thing that I have noticed is that whatever opinion we give in the court is not binding on the court. Most likely we will be called as expert witnesses, or sometimes, since marriage issues are there, sometimes the parties may call, sometimes we may be called as a court witness. Whatever it is, if we just stick to whatever is written in the court, if we justify it, we will be safe. I don't think there would be any problem at all. Enough evidences, justifications need to be given for whatever we have written in the file, and we have to stick to it. And it's also that it is not, the court can decide whether to take our opinion or no. Finally, it is up to the court. We are there just to help the court in helping the court in taking those decisions. If the court is not satisfied with our opinion, the court may go to another expert, But whatever is to be done from our side, we will have to do. And the other clinical things, coming to clinical things, proper information provision for the parties is absolutely essential. Many a times we get a request from one side or the other. Doctor, you tell us to marry or not. This is a very, very common clinical scenario that we encounter in our OPDs and inpatients. So that is a tricky kind of thing. Many a times patients have the patients and their families do whatever they want to do, whatever we say. But if we are not clear, and if we have not documented that in the file, tomorrow they may come back and say that because doctor, you said that I've got things, I've got my ward married. That kind of scenario also is very, very common. So it is essential for us to not decide on behalf of the patient. That is very, very important. We should provide proper information about the illness, about the consequences, about the obligations of marriage, what are the possible scenarios if they conceal, if they don't conceal. See, ultimately the decision is with the patient and their families. The decision is not ours. Our responsibility is to give proper information and let them decide. And that has to be clearly documented in the file so that we also will be safe, tomorrow. So these are some of the things that come to my mind, sir. With regards to this, I'd like to stop here. Thank you.
Thank you, sir. So the bottom line is documentation and involving our colleagues, seniors as well as our junior colleagues if they are competent. So accordingly we can proceed with such type of cases and we can face the law also in the way. Thank you very much, sir.
Yeah.
Domestic violence is a very common problem in society, not only in psychiatric patients, and I believe it is general neutral. I don't know how many will agree, but however, the law says protection of women, and I will request Dr. Malatesh to illuminate us about this act and what is the role of psychiatrists.
So this Domestic Violence Act was actually enacted in 2005, Protection of Women from Domestic Violence Act. Of course, it should not be just women, it will be men as well, that's true, but maybe in the future that legislation will come. So before this legislation got enacted, actually there is one more IPC section which is supposed to protect women from dowry related harassment as well. That is IPC 498. So why did this legislation come then is the question. Because this legislation was supposed to provide more effective protection to the women and also provide additional safeguards, additional compensatory mechanisms so that the victims' problems are addressed effectively. Not just the accused is punished, put in the jail, but also the victims' needs are taken care of. That was the main intention behind bringing up this particular legislation. This has got some 5 chapters and 37 sections. The first chapter defines who is victim, who is accused basically. So victim is defined as a woman clearly. So men cannot be victim as per this this act at all. Only women can be victim. And then who is accused is also defined. Initially it was defined that only male can be accused, adult male. But then there is one landmark case in 2006 I think, where that adult male was dropped. So then it became like accused can be both men or women. And third definition which is important is what is the relationship between victim and the accused. That's also defined there. The relationship should be something that is there within the household. It can be something like father and daughter. The general misconception is that it is only wife and husband. It's not so. Wife can file on husband, that's true, but it can also be something like daughter-in-law filing complaint on father-in-law or mother-in-law, or sister filing complaint on brother. It can be anything, any relationship within the household. Victim should be female, accused can be either male or a female. That's one of the interesting point of this particular legislation. And one more interesting point to note down is whether this is a criminal law or civil law. That confusion is there basically. The procedure that's adopted in the law legislation is basically criminal. CRPC procedures are adopted, that is criminal in nature. But the punishment is all civil in nature. That is compensation. Those include something like monetary compensation to the victim or providing arrangement for the shelter of the victim, such sort of thing, which are civil in nature basically. And this act also defines what are the different types of violences. Violence can be either physical violence, sexual violence, emotional violence, or financial violence. All these violence can be brought up under this particular legislation. And also, a woman can file case under both the legislations, like under Domestic Violence Act also a case can be filed. Simultaneously, IPC 498 case can also be filed basically. But the punishment in IPC 498 is very severe, that is 3 years of imprisonment, which is not so in this particular legislation. And what is the role of psychiatrist basically? The role of psychiatrist comes into play in 2 particular sections of this particular act. One is section 14, which speaks about counseling for the parties involved. Either the parties can come to you directly because there is some amount of disturbance that's going on in the family. Then you should actually, when such thing occurs, you should actually explain the victim this particular legislation, the provisions in the legislation, she can go and complain a case under this act or under 498. All these things needs to be, I mean, that is our responsibility basically. That's also defined in section 5 as duties of the service providers. It's mentioned like that. We are service providers basically. It's our duty to explain the victim their rights basically. So that's how the psychiatrist comes into play in this particular legislation. And one more thing is, court can also direct both the parties to you for counseling. Then you should also get prepared with a report basically. The court might ask, and the report should ideally consist of type of mental illness that the person is suffering, if they are suffering from, the prognosis, the treatment that you offered, and functionality, if there is any disability. All these things need to be written down in detail. So just presence of mere psychiatric illness is not sufficient. All other details, especially functionality of the patient, is very important in all these cases. So that's it.
Thank you, Dr. Malathesh, for a very clear exposition.
Okay, so we will move on to the next question. This is for Dr. Thorat, sir. I would, sir, like you to tell us something about LGBTQ and, the marriage and related laws. Anything new you would like to tell us?
Thank you, madam, for this interesting question. Like India recently has come across two positive developments basically in the rights of these people, like LGBT community. In 2018, we had seen like a 5-judge bench of Supreme Court has repealed the Article IPC 377, and the homosexuality is legalized in India. And then immediately in 2019, we had come across this Transgenders Genders Protection Act of 2019, which was put in course from the January 2020. So these two acts are a very welcome move towards these communities, and they are welcomed by all of us, or the people working in these particular areas. Especially, but the same-sex marriages are not legalized in India. The Supreme Court has not given a positive view about this. There are a lot of pending cases in the court, especially in the Delhi High Court, regarding the same-sex marriages in India. But it has not been, the process is still going on. Only till date, only one homosexual marriage was granted in India, and that is by the Punjab and Haryana court. I think it was between two women. The marriage was there, and still there was a lot of chaos. There was resistance from the society and from the family members, but the court has given verdict that it is welcome, and then they had got a protection from the police also, and now I think they are living together. So only that one case where the homosexual marriage was granted in India, but there are other many cases which are going in the court, especially in the Delhi High Court. And regarding the transgender, regarding the transgenders, there is one interesting case, like it happened in the Madras High Court in 2019, when Mr. Arun Kumar got married to Srija, who was a trans woman. Initially, the registrar of the marriage of Tuticorin, he denied to give sanction for this marriage, and then Mr. Arun Kumar moved to the Madras High Court, and then the High Court has sanctioned this marriage, saying that according to Hindu Marriage Act, Section 5, he said that the personal liberty and personal space is more important rather than this what the definition of male and woman given in the Hindu Marriage Act, and by granting permission in the wider aspect of Article 29 of personal liberty, the court has granted these transgenders to get married. So that was one case, but there are not many cases, or it's not commonly it is happening. And the new Transgenders Act, which was implemented in 2019, it talks more about their again the discrimination of such communities, and then their social welfare schemes, how they can get their certificates to be done by the district magistrate, and how the hospitals can also help such communities to get the certificate done and then go for the sexual reaffirmation surgeries or procedures. So all this has been mentioned in the Act, but there was no mention regarding the marriages of this Act. But that one example of granting marriage according to Hindu Marriage Act 2000 Section 5, they can, I think, approach for consideration of such marriage.
So any case you would like to tell us about after sex reassignment surgery, any marriage it was either legally approved?
That's what, like I just mentioned, that this case was in Madras High Court, where Mr. Arun Kumar had get married to a trans woman, Srija. She was a trans woman after the surgery, and then it was fight in the court, and then court has given positive decision. They had granted their marriage as success is legal.
Okay, thank you, sir.
So, till now what we have seen, these acts, they are of 1920s, 1960s, whatever. So, many acts are these past acts. So, presently and in future, regarding this marriage, mental health issues, marriage, mental illnesses and the law, what is your perspective as a legal person? What do you see, like what Dr. Nishikant he has discussed, that now transgender marriages and all those things, this court has taken a stand on that. They has given firm directives. So how do you see this legal perspective will evolve in next 10 years, 20 years, or by 2050? What is your perspective, ma'am?
I think we are evolving. I would say that while there are certain judgments that are coming that are taking us 2 steps forward, there are also certain judgments that are getting us 2 steps backwards. So I think we are an evolving society. To what Dr. Thorat said, I just want to add to this whole issue of LGBTQ. Just very recently, just last week, Supreme Court has given a judgment where they have said that not only typical marriages but atypical marriages also must be considered, not marriage, atypical family relations must be considered, and they must be given the benefits that a family gets, which includes homosexuals as well. And I think that was a very progressive judgment coming from Justice D.Y. Chandrachud. So I think what is important, while we've been talking about cruelty and mental illness and all these topics, I think there are, like for example, he mentioned about the Protection of Women from Domestic Violence Act, and I've been very fortunate that I've been part of the consultations to draft that law, and it's important that that's one law that recognized that medical help must be a service provider, and they must be part of the law where the judge can say that you can get medical aid in issues like this, which I think is very important. Or counseling should be a service provider, counselors should be service providers. So I think that's hopeful. I think we need to read all these laws. While the marriage laws, like I said, are very ancient, but the new laws that are coming up, for example, the Mental Health Act of 2017, which says that you have a right to access to treatment. I think that is important. But what is happening mostly is that there's still a lot of taboo around mental illness. We are still not accepting the fact that there can be mental illness and some of the mental illness is curable. And that is where a lot of families who believe in superstitions are not coming forth and saying that, oh yes, my daughter or my son does have this mental illness, but this is the treatment that they're going through, and they are capable of performing the duties that come in a marriage. And that's where the marriages are becoming voidable, or annulment or divorce becoming grounds for more litigation. So I think we need to look ahead of, probably the pandemic has taught us some things, and we need to look ahead and see, okay, these are not the only defined medical illnesses. There could be more that may come. Are our laws going to be evolving? Are we going to wait for years and years before we get a change in the law? We took so many years to get a mental health act, and we were relying on a very old act that did not talk of treatment or access to treatment, or did not say that this becomes a right. So I think it's about doing away with the taboos related to mental illness and accepting, yeah, this is the way of life. I have a lot of clients who say that I feel stressed, I went under depression, but I do not want to talk that in my marital dispute, because then that will be considered like I'm unfit to be in a marriage. But don't we all go through those bouts of stress and depression, and is that such a taboo that we can't talk about it? But I have to give to client autonomy and finally, do what they want me to do. But I think we definitely need to evolve as a society, and law, I think, plays a very important role in regulating, these matters that impact on life. And I think that's where it's not just the laws that are passed by the parliament, but I think how are they interpreted by the court? I think that becomes even more important. And for that, I think the people in the judiciary also need to know that they also need to be educated. They also need to be sensitized. Sometimes some judges just think they're way above everybody and they know everything, but that's not true. We also need to go through sensitization, and we also need to go through understanding the intricacies from the medical point of view also. And I think that kind of a collaboration between the medical fraternity, between the legal fraternity, I think that is something to look forward to in the future.
Thank you, madam. Thank you for the nice elaboration. With this, I think the take-home message regarding whatever your views are, it's not the responsibility of parliament, it's not the responsibility of judiciary only, it's the responsibility of whole community to evolve all together to bring new laws which will be helpful for the mankind. That's the message I think you want to give to everybody. Thank you, ma'am.
The session is now open for questions, comments from the audience.
My question is to Advocate ma'am. The construct of mental illness is more of psychosocial rather than an absolute medical construct. How does the court deal with this bias? How does the court preserve its immunity from the conflict of interest of stakeholders?
I would say that different courts deal differently, and there is no standard as such that is set, because while we do define that, the petitioners look at subjectivity in defining what they are going through, the judge is not always objective in looking at this. So I think the judge needs to be objective while they do consider the, like I said, understanding this from the context of the case. They need to be objective in understanding this. I think the other thing that we do lack in the Indian system is to ask for expert opinion and to understand it from them. And that is something that the court does not engage in as much as they should in topics where they are not experts. And I think that is something that must happen, so that there are less, I wouldn't call it mistakes, but there's more objectivity in the way we look at cases, because we are looking at what the judgments come as precedents to other cases, and I think setting those examples that are more progressive from everybody's point of view, from from the society point of view, becomes very important. And I think that's something that the court need to be more cognizant of.
Yeah, 1 minute. Please identify yourself before asking the question. So,
Yeah, myself, I'm Prasad Deshpande. I work as a professor of psychiatry.
Hello, everyone. My name is Dr. Deepak L. Joseph. My question here is with respect to cruelty, mental cruelty and documentary evidence. When we say mental cruelty and documentary evidence, I believe there is some kind of written documentation. But in today's world, where it's so technologically advanced, can WhatsApp messages, can video calls or audio calls constitute to documentary evidences, and what is the stand of law in these kind of situations when there is dispute, domestic violence or between husband and wife or even family members? So can that be constituted as mental cruelty, and these things can be taken as documentary evidences? Thank you. And yes ma'am, that's for you. And another thing is also, please, if somebody else in the audience in the panel can give us how this impacts clinicians, where do we stand in all of such kind of situations where technology plays a part or social media plays a part? Thank you.
I think a very relevant question in today's times, because for many years I think we just thought that cruelty happens when you stay together. But with the advent of technology, it also happens from any geographical distance, is something that is turning out to be true. Are these evidences valid in the court? The answer to that is yes. Under the Evidence Act, you have to get a certificate saying that these are not tampered with and these are evidences coming from the source that they are mentioning. So yeah, you get a certificate. There are forensic labs who give you that kind of a certificate, and you have that certificate. It can definitely be proved in the court. So, but yeah, not every kind of a cruelty will have a documentary evidence. There would be some that would have a documentary evidence, but there would be some that wouldn't have a documentary evidence. A tricky question sometimes that comes to us is that when somebody is recording a conversation without the consent of the other person, and that's not an informed consent. But having said that, if I have to practically think, if I have to tell him, I'm going to record the conversation and use this in the court, will he even speak? So this will happen without consent, as long as it's not tampered, is what we will have to look for. So I think it's a fine line between what are the rights and responsibilities and what is practically the way to do it. And sometimes that line can be very blur, because we are also talking of ethics here. So again, it is for the court to decide whether this should be admissible or not. But generally these days, we do have messages from WhatsApp or emails or video calls as allowed in the court as admissible. In fact, one of the cases in the Bombay High Court, the judge himself sent a notice using WhatsApp after verifying on a true caller that this is the person I have to send the notice to, because the other party was not receiving the notice from the bailiff. So yeah, the technology is used in the court these days.
I'm Major Sijo. I'm a faculty at Con FMC. My question is that I came across a lady whose husband underwent a gender reassignment surgery. 2 years into their marriage and daughter together, now this lady is in dilemma whether she'll be eligible for remuneration. So does that come under this perspective? How do I explain it to her?
Yes, in that case, if, as you mentioned, SRS surgery has been done, the wife can, like the person can approach the court or for remuneration of the whatever the surgery has been done. The question is not very clear actually. I think you asked about husband having undergone SRS surgery and then wife approaches the court for compensation?
Compensation.
Okay, I think then it's a very clear case of, as I told about the section that deals with the voidable marriages, where material facts which are very relevant to the marriage, if they are hidden, then it's a fraud. If the SRS surgery was not revealed to the wife and the marriage has been done, yeah.
The surgery was done after their marriage. After they got married and they had a daughter together, the husband underwent surgery 2 years into their marriage.
Okay, fine. Then?
So now the lady has approached the court.
Lady has approached?
Approached the court.
Court, okay, for?
So now she is asking for remuneration.
Asking for?
Remuneration.
Alimony?
Yeah.
I mean, if she knew that he is undergoing SRS and if she did not had any objection, then I am not sure if she can go for that. Maybe madam can answer that.
I think that would really depend on the ground as to what she's asking. Alimony is not only asked in divorce cases. Sometimes you can just have an independent case of maintenance. Alimony is more permanent. Maintenance is on a monthly basis. So there are different laws under the Hindu law, under the under the Criminal Procedure Code, under the Domestic Violence Act, where you can ask for maintenance not so much because you're seeking a divorce, but because you are incapable of taking care of yourself. You do not have sufficient means to take care of yourself or your children, and the other person is not taking care of you. There is economic violence, or they're staying separately but not filed for divorce, but they're staying separately, and there's merely a case of maintenance. So the ground for maintenance will be considered basis the potential of both the parties to earn. And now there is a Supreme Court judgment that says that there has to be a disclosure of assets by an affidavit, and there are strict norms about it. The lady also has to give a disclosure of assets, the other party also has to give a disclosure of assets, and basis what is their potential, who earns what is the standard of living that they have, what is the life, what kind of a life do they live, and what are they entitled to, that will decide what is the maintenance amount that they will get.
Good morning, ma'am. Myself, Vaishali. My question is to the ma'am. As we spoke a lot about the cruelty and violence in like domestic violence, but at the end we found that it is all subjective matter. If I feel this is violence, but maybe court they do not find it as violence, then does the law system they has a particular definition of violence, so it will satisfy everyone?
No. And that cannot be, because violence or cruelty is always subjective. Like I said, I may be so thick-skinned that somebody name calling me for 100 times and I won't care to what they say, but somebody might be very sensitive to the same thing and may say this amounts to cruelty. So it definitely the social cultural context has to be considered, the context of every case has to be considered, and that is why most lawyers fail to write the impact of cruelty, because cruelty can't be shown. It has to be, the person is undergoing it, the person feels it, and that needs to be described very well in the petition, and most lawyers fail to do that, and that needs to be done for the judge to understand. So there's nothing like, while there are many judgments that say what is cruelty and what is not cruelty, there's always a new ground for cruelty that can come up because it's so subjective, right? So you can't have a fixed norm to say only this amounts to cruelty. You can't have a list to say only this amounts to cruelty. So it will come with subjectivity, always.
Thank you, ma'am.
You will all agree that the panelists have given a very wonderful exposition and it has created a lot of interest. On behalf of the moderators, I thank the panelists for their wonderful talk. With this, we declare the session closed.
for this stimulating discussion. It was truly a knowledge-enriching session.
We would now like to felicitate our moderators and panelists. It is our pleasure to inform everyone that the artwork of our felicitation gifts have been prepared by our psychiatric patients of GMC Medical College and MIMH, Pune.
I request Dr. Suprakash Chaudhary, sir, to felicitate Dr. C. Naveen Kumar, sir.
Dr. Naveen Kumar, thanks a lot.
Namaste, sir. Thank you. Namaste, everyone.
Now I request Dr. Sharmishta Deshpande ma'am to felicitate Dr. Nishikant Thoraz.
I request Dr. Manjeet Santre, sir, to felicitate Dr. B.C. Maltesh, sir.
May I now request Dr. Suprakash Chaudhary to felicitate Advocate Rama Sarode ma'am.
I request Dr. Umesh Nagapurkar, sir, Consultant Psychiatrist in Nashik and Vice President IPS West Zone, to felicitate Dr. Suprakash Chaudhary, sir.
I request Dr. Vilas Bhailume sir, ex-Superintendent Regional Mental Hospital Yerwada, to felicitate Dr. Sharmishta Deshpande ma'am.
I request Dr. Jaisuklal Parmar, sir, Consultant Psychiatrist at Vapi and Direct Council Member, Indian Psychiatric Society, to felicitate Dr. Manjeet Santre, sir.
I'm happy to inform you that the mementos which were used for the felicitation were made by the patients of Sassoon General Hospital Psychiatry Department. The artwork also has been done by them.
This brings us to the end of Panel 1 discussion.